Right. I'd like to welcome everyone to the hearing today. The meeting is called to order at 9:30 a.m. Today's proceedings are being held as a hybrid meeting by way of in-person attendance and teleconference to hear minor variance applications PLMV 2026-014 and PLMV 2026-020. The Committee of Adjustment is appointed by Council to consider applications for minor variances to the zoning bylaw pursuant to Section 45 of the Planning Act. A minor variant may be granted provided it meets the four tests, namely that the variance meets the general intent of the official plan and zoning bylaw, that it is minor in nature, and that it is desirable for the appropriate development or use of the land, building, or structure. The Planning Act requires that the public hearing be held. The public hearing serves two purposes. First, to present to the Committee of Adjustment and public the details to the application, and second, to receive comments from the public and agencies before a decision is made. All the submissions form part of the public record. Both the Secretary Treasurer and myself will be responsible to ensure that all parties and the committee members can hear one another during the meeting. For those attending by teleconference, if at any time you are having difficulties hearing what is being said, please say so or click the raise hand button or dial *9. We kindly ask that everyone speak slowly and clearly when addressing the committee. If you are of the opinion that holding the hearing as an electronic hearing is likely to cause significant prejudice, we ask that you advise the committee at the earliest opportunity and the matter can be addressed accordingly. Any applicant or agent that is in attendance to today's meeting for a specific application may leave the meeting once their application has been considered by the committee. Any applicant, agent, or members of the public wishing to address the committee for a specific application is reminded that presentations are limited to 10 minutes per person. If you are using a computer or electronic device, please ensure that your microphone is turned on and your audio settings are not muted. All parties will be verbally acknowledged before being asked to proceed. At this time, I'll ask that anyone who objects to an electronic hearing for a matter on today's agenda or is having difficulty hearing what is being said, please click the raise hand button or dial *9. We are good to go. The committee will first adopt the agenda. Would the Secretary Treasurer please read the resolution?
Good morning, committee. Through you, Mr. Chair, moved by G. Neville and seconded by John Agat, be it resolved that the Committee of Adjustment hereby approves the agenda of the April 27th, 2026 meeting as circulated.
All those in favor? That is carried. Do any of the committee members have a pecuniary interest in the application being heard today? No. There are minutes to approve from the February 23rd, 2026 meeting. Does the committee have any comments or questions about those minutes as circulated? No comments. Would the Secretary Treasurer please read the resolution?
Moved by John Agat, seconded by G. Neville, be it resolved that the Committee of Adjustment hereby approves the meeting minutes of the February 23rd, 2026 meeting as circulated.
All those in favor? That is carried. I now declare this to be a public hearing for application PLMV 2026. Is it 2026 or 2025? 2026-014, located in Park Lot 31, Concession 10, Geographic Township of Minden, 1105 Keewatin Road, Sawyers Lake. Would the planner please summarize the proposed variance and any correspondence received to date regarding this application?
Good morning, committee. Through you, Mr. Chair. The application was submitted by Highland Design on behalf of the property owners, Stephen and Laura Reed. The property known as 1105 Keewatin Road comprises an area of approximately 1.26 acres with frontage of approximately 32.31 meters. As per the application, the property is currently developed for recreational residential use with a 2-story dwelling, 2 small sheds, and a boathouse. As proposed, the owners wish to construct a new two-story garage having a ground floor area of 136.8 square meters. The upper floor is intended to be used for storage only. The proposed garage would be located more than 40 meters from the shoreline of Sawyers Lake and is proposed to have a maximum mean height of 6 meters. It is noted that an existing hydro utility line traverses through the property and across the proposed building site. The property owners have corresponded with Hydro One and intend to have the overhead line relocated to accommodate the building site. The application requires the following relief from the township zoning bylaw from section 5.2 to permit a reduced southern interior side yard setback of 1.6 meters or 5.3 feet on the southeast corner of the garage, whereas a setback of 4.5 meters or 15 feet is otherwise required. The application is subject to the 4 tests of a minor variance as outlined in the Planning Act. And we'll go through those. Is the application minor in nature? When assessing whether the application is minor in nature, the consideration must relate to the potential impacts of the variance requested. The proposed variance will permit a reduced southern interior side yard setback for the new garage. The proposed setback, although reduced, remains sufficient for maintenance of the building itself and land around it. The neighboring property is developed with a similar accessory use directly adjacent to the new garage site. The garage will exceed the required setbacks to the shoreline and will be located further from the shoreline than the neighboring dwelling. The proposed development is compatible with the surrounding land uses and there are no anticipated impacts to the lake. The application is therefore found to be minor in nature. Is the application desirable for the appropriate development or use of the land, building, or structure? The application will enable the expanded use of the property to improve the functionality. Garages are permitted in the shoreline residential zone, and the proposed use is consistent with the development of the surrounding area. The property is bisected by Keewaydin Road. Development on the east side of the road is challenged by rough, rocky terrain and elevation changes that would require significant site alteration to accommodate a building site. As proposed, the garage will be located on the west side of the road on the same side as the dwelling, which improves access from the dwelling and also safety for the property owners. Based on the information from the owners and as confirmed during a staff site visit, the area for the proposed garage requires minimal tree removal. As proposed, the garage will be located in an already cleared area that's currently being used as a parking area and outdoor vehicle storage. There's an existing septic system north of the proposed garage site. This inhibits the opportunity to shift the building further to the north and increase the side lot line setback to the south. The proposed garage remains consistent and compatible with the established pattern of the development in the surrounding neighborhood, and therefore the application is found to be desirable for the appropriate development or use of the land, building, or structure. And so does the proposal uphold the official plan, the intent of the official plan? The subject property is designated waterfront on Schedule A of our township's official plan. Sawyers Lake is recognized as moderately sensitive to additional shoreline development or nearing capacity in terms of water quality. However, properties on moderately sensitive lakes retain existing development rights, and that includes permitted accessory uses such as garages. The official plan promotes a 30-meter setback from the new development in the waterfront area. The proposed 2-story garage will far exceed that requirement. The garage will be located farther from the shoreline and positioned behind the existing dwelling. No work will be completed in the immediate shoreline area and no impacts to the balance of the built and natural form within the shoreline area are expected. The application is considered to uphold the general direction and purpose of the official plan. Does the application uphold the general intent of the proposed, and purpose of the zoning bylaw? The subject property is zoned shoreline residential on Schedule 8 of our township zoning bylaw. The proposed variance will permit a reduced side yard setback of 1.6 meters to the interior side lot line to the south. Save and accept the side yard setback, all others All other setbacks as per section 5.2 will be met or exceeded. The proposed garage will also exceed the 3-meter setback required from the private right-of-way. A garage is permitted use on the property. As proposed, the second-story storage area has a usable area of 136.8 square meters. As confirmed by the owners, the upper story will be used for storage only. Due to the size, a sleeping cabin would be prohibited on the second story. Should the proposed use change to a sleeping cabin in the future, planning approvals and significant renovations would be required to comply with the township zoning bylaw. I would like to point out that the original design of the building proposed did exceed the maximum height of 6 meters. However, the applicant revised the application to confirm that the garage will comply, and revisions to the building design drawings will be implemented at the time of building permit, subject to approval of this application. The proposed building site is significantly set back from the shoreline. The southern interior side yard setback is proposed to be 1.6. Apparently that's a repeat. You've already heard that. Apologies. The intent of the side yard setback provision is to ensure appropriate separation from neighboring properties for maintenance and compatibility. Given the significant setback from the shoreline, the adjacent land use also being a garage, and the current use of the land as an outdoor vehicle parking area, the reduction in the side yard setback does not offend the intent of the requirement. The proposed development will maintain compliance with property lot coverage regulations for both total and accessory building lot coverage. And therefore, the application is considered to uphold the general intent and purpose of the zoning bylaw. The application is also required to be consistent with the provincial planning statement, PPS. Under the policies of the PPS, the subject property is considered rural lands, and permitted uses on rural lands include resource-based recreational uses, such as recreational dwellings and associated accessory uses that maintain the rural character and can be sustained by rural service levels. The application does not conflict with policies of the PPS. Notice of the application was circulated to neighboring landowners and commenting agencies according to the Planning Act on April 17th, 2026. A letter of support from the adjacent property owner to the south, or from an adjacent property owner to the south, was submitted with the application. As of the date of writing the report and today, no further comments were received. So the application appears to meet the 4 tests of a minor variance and is consistent with the policies of the PPS. And it is recommended that the application PLMV 2026-014 be approved, subject to the conditions identified in the report.
Thank you. Is the applicant or property owner here today?
Through the chair, Mr. Ben DiCarlo's attending virtually as the applicant.
All right. Would the applicant like to state his name and provide any additional information to the committee?
Yes, good morning. My name is Ben DiCarlo, through you, Chair. I'd just like to thank Jody for her report. I'd just like to reiterate the location that we're trying to put this in. From a site constraint perspective is really what works. It's already cleared adjacent to an existing accessory use structure, being a garage. And again, we're limited in where we can go north in terms of away from that property line due to the current septic location. Furthermore, it keeps the garage up on top of that. I know it's difficult to see with the photos and the snowbanks and such, but it keeps it up on top of that elevation when you drive in. If we go any further, like towards the existing dwelling, it drops off, and then we're into vegetation there as well. So it just kind of lends itself to the ideal location. The only other comment I have is with respect to the upper floor area from a usability perspective. It's not 137 square meters just due to roof slopes and headroom and such. It'll be less than that.
Okay, thank you for that. Are there any other members of the public who would like to speak to this application? We'll start with anyone attending electronically. No one else. And I see no one else present. Okay. And there's no one in person. Are there any questions from the committee to the applicant, the planner, or the persons who have made presentation? We're good to go. Yes. Are there any further questions or comments from the committee to the applicants? No. As there are no further comments, would the secretary treasurer please read the proposed conditions for the minor variance?
Yes, through you, Mr. Chair. So the conditions are more or less the typical ones. The first being just that the minor variance relates only to the garage. The second being that construction shall proceed substantially in accordance with the revised site plan and amendment letter. There is a condition that the overhead hydro lines, which are currently impeding the building site, will need to either be relocated or otherwise will require confirmation from Hydro One that there's no concerns with the clearance of the garage from the line. That an Ontario land surveyor shall confirm the required setback, that the building permit be applied for within 24 months with any required documentation, and that failing any part of those conditions, that the application would be refused.
Are there any questions or comments from the committee regarding these conditions or thoughts about why? make it this?
Yes, any reasons for support or
Yeah, I
not
find-
support
I
would be
find
great.
that this is minor. It's like practical place to put the garage.
For me, they're farther away from the water and the neighbors has no problem.
Just writing those out.
Hearing all the evidence before it, is the committee ready to make a decision? Would the secretary treasurer please read the resolution?
Yes. Moved by Paul Riddles and seconded by Honoree Tall. Whereas the Committee of Adjustment considered the written and oral submissions relating to application PLNB 2026-014 Reed made at the hearing. And whereas it is the opinion of the committee that the relief granted maintains the general intent of the official plan and zoning bylaw, is appropriate and desirable for the area, and is a minor in nature, and more specifically for the following reasons. That given the site conditions, this is the only practical location for the garage, that it is further from the water, and that the neighbors have no concern. Now, therefore, it is the decision of the committee that application PLNB 2026-014 requesting relief from the requirements of bylaw 06-10 as amended to permit the following: from section 5.2 to permit a reduced southern interior side yard setback of 1.6 meters or 5.3 feet for the southeast corner of a garage, whereas a setback of 4.5 meters or 15 feet is otherwise required, subject to the following conditions: that approval of the minor variance should only relate to the proposed new 136.8 square meter or 1,472 square foot two-story garage, with the second story to be used for storage only, construction of which shall comply with all other applicable law. The construction shall proceed substantially in accordance with the revised site plan and amendment letter submitted to the township on April 9th, put before the committee on April 27th, 2026, and forming part of this decision. Save and except for the inclusion of any additional information as may be required for site plan review. That the overhead hydro lines impeding the building site location be relocated to achieve compliance with Hydro One setback requirements, or otherwise that confirmation is received that a reduced setback will be permitted by Hydro One. That an Ontario land surveyor shall confirm the required setbacks in accordance with the approved site plan to the satisfaction of the township. That the building permit be applied for within 24 months of the approval of this application following submission to the building department of the appropriate application fees and any supporting information is deemed to be required by the chief building official. And that failing any part of the foregoing conditions, this application shall deem to be refused.
All those in favor? That is carried. Good luck with your construction.
Thank you, everyone.
I now declare this to be a public hearing for application PLMV 2026020, located in Part Lot 10, Concession A, Geographic Township of Minden, 2038 Scotch Line Road. Would the Secretary Treasurer please summarize the proposed variance and any correspondence received to date regarding this application?
Thank you, Mr. Chair. Through you, application PLMV 2026-020 was submitted under Section 45 of the Planning Act. This property is owned by the township and is locally known as Scotch Line Landfill. The township has been approved by the Ministry of Environment, Conservation and Parks for a transfer station to improve function and longevity of the landfill. The landfill area is currently supporting operational and administrative functions, as well as the landfill itself. And the transfer station will enable those components, which includes the waste disposal bins and the attendant shed, to be separated from the disposal area, and will also result in an improved setback to the road. Most of the site is either exempt from zoning regulations or is regulated under Section 4.8.4 of the non-complying structures. However, as part of the transfer station, scales and a scale house will be added to the property. The scale house is essentially a small office space where staff will also administer the function of the scales themselves. It's only intended for a couple of staff at one time, so it's a small building, only 160 square feet in size. Because it's a new building, however, it is subject to Section 5.2, which requires a setback of 100 meters or 328 feet to all lot lines. The scale house was originally intended to comply with setbacks. However, on-site investigations during site preparations identified that soil conditions towards the back of the licensed area would pose issues with safe or proper construction for footings due to the variability and quality of the bedrock. To avoid that area, the development must be shifted slightly forward, and the setback for the scale house would then need to be reduced a total of 3.2 meters or 10.5 feet to the front lot line to ensure that construction is placed over stable soil and bedrock. So the resulting front yard setback would be 96.8 meters or 317.5 feet. As submitted, the application requires relief from the township zoning bylaw, being from Section 5.2, to permit a scale house to be constructed with a setback of 96.8 meters from the front lot line, whereas otherwise a setback of 100 meters is required. The application is subject to 4 tests of the minor variance as outlined in the Planning Act, which I'll go over. The first is the application minor in nature. So when assessing for whether or not an application is minor, we give consideration to potential impacts of the variance that's being requested. As mentioned, the scale house would provide for an office space and is only 160 square feet in size. The administrative use of the building is not considered incompatible with surrounding land uses. It would also still maintain quite a significant setback from the road and is a small footprint, particularly considering the overall footprint that will be on the property. There is no impact anticipated for reduction, therefore, of the 3.2 meters or 10.5 feet. The building being set back almost 97 meters or 317.5 feet would not create any traffic issues. Traffic is expected to actually improve as a lot of the operation is currently quite close to the road, approximately only 16 meters for some of the components, whereas the scale house will actually direct vehicles much further into the property and provide for greater area for vehicular movement. So the application is found to be minor in nature. Is the application desirable for the appropriate development or use of the land, building, or structure? The use of the property as a landfill is permitted and is encouraged both by the Ministry of Environment, Conservation and Parks and through local planning documents. The scale house, as mentioned, will provide for office and administrative space to support that permitted use. Relocating the scale house will also ensure that it's located over stable soils that can support that building and the scales. The application is therefore found to be desirable for the appropriate development and use of the land and building. The third test, does the application uphold the general intent and purpose of the official plan? The official plan does not contemplate an industrial land use designation, so it is lumped under residential and parks and open space on Schedule A. However, the property is identified as open waste management site on Schedule E. The official plan directs that sites that are identified on Schedule E are to continue to be used for waste disposal, and therefore only policies relevant to waste management are relevant to the subject lands. The official plan does not regulate location of buildings or structures for waste disposal sites. And as already mentioned, the scale house, primarily as an office space, is not considered a disruptive component of the operation and is also anticipated to improve the function of the site, which will in turn improve compatibility with surrounding land uses. Policy otherwise directs that the appropriate use of the land is regulated through approval of the ministry, which both the landfill and the transfer station achieve through environmental compliance approval. The application is therefore considered to uphold the general direction and purpose of the official plan. The fourth test is the application uphold the general intent and purpose of the zoning bylaw. So the subject property is zoned waste disposal industrial, or M3. The setback requirements of section 5.2 are intended to limit or prevent potential land use compatibility issues. As mentioned, the scale house does not pose compatibility issues given it's intended to provide an improved administrative function, and no waste is stored within proximity to the building. The scale house will also still maintain a significant setback to the front lot line, and all other setbacks and development standards related to the building will otherwise be significantly exceeded. The application is considered to uphold the general intent and purpose of the zoning bylaw. The application is also required to be consistent with the provincial planning statement, the PPS. The subject property is within the settlement area. However, those lands are more appropriately classified as a component of the township's infrastructure and is further identified as a major facility. The PPS speaks to avoiding land use compatibility issues between major facilities and sensitive land uses, such as residential land uses. The policies don't strictly apply in this case because the landfill and the residential uses are all largely existing. However, as discussed already, the scale house is expected to improve existing compatibility with surrounding land uses. The PPS directs that long-term viability of major facilities, in this case, the landfill and transfer station, are to be protected. It's therefore generally sensitive land uses that are restricted to ensure the continued use and function of major facilities as a municipal service. The PPS otherwise does not comment on the location of buildings or structures, and the application is therefore consistent with the policies of the PPS. Notice of the application was circulated to neighboring landowners, as well as commenting agencies on April 17th, 2026. There was also a sign notice posted on the property. We received comments from MTO just confirming that the property is outside of their control area and they therefore didn't have any comments. We've received no other written comments prior to this meeting. Based on the assessment of the application as currently proposed, it meets the 4 tests of a minor variance and is consistent with the policies of the PPS. It's therefore recommended that application PLMV 2026-020 be approved subject to the conditions of the report.
Thank you. Is the applicant or property owner or representative here today?
Mr. Mike Timmons is attending virtually as the applicant.
All right, welcome, Mike. Do you have any information you would share with the committee today?
No, through the chair, I don't have anything to add. I believe staff gave a pretty thorough review there and I could take questions, but I don't have any further comments.
Thank you. Are there any members of the public who would like to speak to this application? We'll start with anyone attending electronically. We have no one attending electronically. Is there anyone attending in person? Are there any questions or comments from the committee to the applicant's plan or any persons who have made presentation? And I'll start with that because I've noted that in the recommendations, we normally ask for an Ontario land surveyor to confirm that the setbacks, if approved, have been met. Could you comment on that, or would Mike like to comment on that?
Through you, Mr. Chair, I can comment on that. We didn't include that as a condition in this case because it has already been done. An Ontario land surveyor already went out to the property and confirmed the precise setback that will be met, which is the 96.8. So it didn't need to be a condition of this application.
Okay. Is there any other members of the committee have any comments, questions, concerns, thoughts that they wish to share? All right. Unless there are any other further questions or comments from the committee to the applicants, comments may be reasons why the application may or may not be supported for the purposes of a decision.
I think moving it back from like 16 meters to 97 meters, like,
Yes,
is significant.
is a major improvement.
Yes.
Yes. I also find that infringing on the 100 meters by 3 meters is very minor. Are there any other comments? Yes, Gene.
Just finally glad to see that we're getting scales there. It's you know, such a mass improvement than the attendance trying to you know,
Yes.
guess how much there is, because it's kind of hard to tell. Stuff is in bags and everything else. So I'm finally glad that they're getting the scales.
Yes, and numerous bins to put the recycling in. That's very good. All right. If there are no more questions regarding this, I think someone is supposed to read something now.
Through Mr. Chair, would you like me to read the conditions first? I know we did
Secretary,
discuss
please
them.
read,
Happily. These are again, very similar to the usual standard conditions. The first being that the minor variance will relate to the proposed scale house. The second being that construction shall proceed substantially in accordance with the site and building plans that have been received. The third, that the building permit, if one is required, would be issued by or would be submitted to the chief building official. We did include within 6 months only because site work is already underway. And that failing any part of the foregoing conditions, it would be refused. And as mentioned, we didn't include the OLS requirement because it has been already done.
All right, thank you. Are there any further questions, final questions regarding these conditions? Hearing all the evidence before it, is the committee ready to make a decision? Would Secretary Treasurer please read the resolution?
Moved by John Agate and seconded by Jean Neville. Whereas the Committee of Adjustment considered the written and oral submissions relating to application PLMV 2026-020 Township made at the hearing. And whereas it is the opinion of the committee that the relief granted maintains the general intent of the official plan and zoning bylaw, is appropriate and desirable for the area, and is minor in nature, more specifically for the following reasons: that the site is being improved with increasing setbacks from 16 meters to 97 meters, and that the infringement of 3 meters is very minor in nature. Now, therefore, it is a decision of the committee that application PLMV 2026-020 requesting relief from the requirements of bylaw 06-10 as amended to permit the following: from section 5.2 to permit a scale house to be constructed with a setback of 96.8 meters from the front lot line, whereas otherwise a setback of 100 meters is required, be approved, subject to the following conditions: that approval of the minor variance shall only relate to the proposed scale house, construction of which shall comply with all other applicable law. That construction shall proceed substantially in accordance with the site and building plan submitted to the township on March 2nd, 2006, and put before the committee on April 27th, 2006, informing prior to this decision. That should a building permit be required by the chief building official, that the permit, which is to remain in good standing, be applied for within 6 months of the approval of this application, following submission to the building department of the appropriate application, fees, and supporting information as required by the chief building official. And that failing any part of the foregoing conditions, this application shall deem to be refused.
All those in favor? That is carried. I now declare this matter to be concluded. Is there any other business to discuss today? When is the next meeting, Secretary?
Through you, Mr. Chair, we are anticipating a meeting for May. I believe that's the 25th. I should have probably double checked that ahead of time. Well, yes, May 25th. We're anticipating a meeting.
Well, perfect.
Yes.
All right. Would Secretary Treasurer please read the resolution to adjourn?
Moved by John Agate, Agate and sorry, John. Moved by John Agate, seconded by Paul Radals. Be it resolved that the Committee of Adjustment meeting be adjourned at 10:04 a.m. on April 27th, 2026. The committee will reconvene on May 25th, 2026, providing applications have been received.
All those in favor? We are adjourned.